Hey guys, today we're going to talk about magistrate court suits. Now, magistrate court suits are for claims below $60,000. They are governed by Order 108 of the Rules of Court for lawsuits started after November 2014. This is a new process, which features upfront disclosure of documents, together with early and robust case management. The primary aim of the new simplified process is to facilitate early resolution of the dispute. One of the key features of the new simplified process is upfront discovery. What is discovery? Discovery is the provision of the documents in your possession. Usually, for most lawsuits, discovery is done after close of pleadings. That means after the writ of summons, statement of claim, the defense, and the reply have been filed. The reason for this is that you don't want to show your opponent your cards. You don't want him to let him know what documents you have that may prejudice your case or that are in favor of your case. However, now under the simplified proceedings under Order 108 of the Rules of Court, it forces you to disclose all documents in your possession upfront. So the list of documents, the index, is usually attached and served together with the writ of summons. Another feature of the new simplified proceedings is this thing called the Case Management Conference, also known as a CMC. In other lawsuits, the court hearings are called PTCs, pre-trial conferences, but for the new magistrate lawsuits, they are called CMCs. A CMC is essentially a PTC, a pre-trial conference, where the judge, will talk to the two lawyers and try to achieve a resolution. The judge will help parties identify and narrow down the issues, deal with interlocutory applications. Interlocutory means before the trial, or whether there is even a need to take out interlocutory applications. Usually the judge will persuade parties not to take out unnecessary interlocutory applications to keep costs down. The judge will also usually assist the parties to reach a settlement. In fact, I once attended a CMC for a claim. It was $8,000. I was acting for the defendant. During the first CMC, the judge said that it is just not cost effective to go for mediation So the judge told us, both of the lawyers, to take this offline privately and to negotiate amongst the lawyers themselves to reach a settlement. He doesn't even want a case conference. So before the CMC is convened, it is usually convened about a month after the defense is filed. It's generated by the e-litigation platform. The parties are required to make offers to settle. It's on a standard form. You have to make an offer to settle. Usually the first offer to settle is not the genuine offer to settle. They will claim the full amount. They will ask the other party to pay their costs. They just want to be quiet. Another document that has to be filed before the first CMC is alternate dispute resolution forms. So your client has to tick the box whether they want mediation, arbitration, or trial and all that. Most people tick mediation. And then the other party, and then both parties also have to prepare this document called a list of issues in dispute. It's a 2-column document where you have to put the issue in dispute on the left column, and on the right column you have to put the documents or the evidence that the party is relying on. And you also have to state the number of witnesses that will be called in the event of a trial. Order 108, the simplified process, also provides that there are three interlocutory applications which are not allowed under magistrate court suits because they essentially take out a lot of time. First one is Order 14, summary judgment. You can watch one of my earlier videos on Order 14. It's very tedious. And also no discovery, because all discovery is upfront. So you cannot take out applications like specific discovery to ask for specific matters because it's already disclosed up front. There are also no interrogatories. What are interrogatories? They are essentially questions to get the other party to admit to something or to provide statements of fact. After the CMC, it is common for the judge to direct that parties go for mediation. During the mediation process, the mediator, who is also usually a judge, will bring one party to the room, talk to him about the merits of his case, and then bring the other party to the room, do the same thing, try to reach a compromise to settle somewhere in between. And according to the State Court's website, about 80% of lawsuits, magistrate lawsuits, get settled at mediation. From my experience, all my magistrate court lawsuits get settled during mediation because the mediator would usually persuade the parties that going for a trial, the cost of a trial is really too expensive for a claim below $60,000. If parties cannot settle at mediation, Order 108 provides for a simplified trial. Simplified trial means examination of your own witness, you're only allowed 10 minutes. Cross-examination of your witness by the other lawyer, you're allowed a maximum of 60 minutes. So this is to ensure that the trial is not dragged out, prolonged and all that. So what's the cost of a magistrate court trial? Well, for a default judgment, which means essentially just a writ of summons, statement of claim, and the judgment, it could cost as little as $3,000. If you want to know what is default judgment, you can watch one of my other videos on Order 13 default judgment. Essentially, the person that you're suing ignores the writ of summons. For matters that are settled during mediation without a trial, the cost can range from $5,000 to $7,000. Pleadings, attendance at CMC, case management conferences, mediation, so this will add up to be about $5,000 to $8,000. If it goes to a full trial, you can expect a bill of about $20,000, $30,000. In fact, one of my opponents in one case was telling me that for a magistrate court trial, the total billings was about $40,000. So even if you win at the magistrate court's trial for a claim, for example, $60,000, and your legal fees are $40,000, you may not be awarded all your costs. You may be awarded only $20,000. So you 60 minus 20 is 60 minus 20 is $40,000. So you may want to think, is it worthwhile to go all the way to trial and then you get back only $40,000 for a $60,000 claim? So thanks for watching this video on magistrate court suits.